The first case is Trecha versus Remillard. Mr. Jakeway and Ms. Nemeth, good morning. It is nice to see you both.
Good morning.
This is a 15-minute mini oral argument on the application. Mr. Jakeway, you can preserve some of your time for rebuttal, although we'll try and have you manage that. I will go through each of my colleagues sequentially so they can ask you questions to make it a little bit more ordered. Mr. Jakeway, we don't see your camera. Maybe you're doing this without camera, which is okay. I just want to make sure if you want us to see you, you turn your camera on.
Is that working?
We should be on, Judge, now.
I hear you. I just don't see you. Do you want me to see you, or are you?
I would like that if we could.
Okay, so there's a little video camera on the bottom of your Zoom screen, and there's an arrow next to it. You see that? The video camera probably has an X over it, and you could probably just unclick that.
Hold on, just 1 second.
Judge, I appreciate very much your, and I would like to reserve just 1 minute for rebuttal, and my argument will be brief.
No problem. We'll give you a second. We don't have to get started until you're ready with your camera. So we're doing okay for time so far. So far, we're not that behind. There we go. Okay. And if you want to pull the computer or the iPad towards you a little bit, we'll see more of your face. You know, your camera is probably at the top of your screen, and you can sort of pull the screen a little bit in. Well, yeah, we can see you.
Thank you, Judge.
All right. Well, you may proceed, Mr. Jakeway. Go ahead, floor is yours.
In our application for leave, you've asked us to address the limited issue, assuming Bradley Trecha was a participant in the recreational activity of tennis, was the particular risk that caused his injury reasonably foreseeable. The appellee defendant, following losing a tennis practice match, removed a ball from his pocket in frustration for hitting a tennis ball into the net. He hit a ball with force behind him toward a fence without looking, striking Bradley Trecha in the eye, causing serious injury. His act of hitting the ball without looking was an intentional act. The injury, however, Judge, was not intended. The reckless misconduct standard, however, we are told, only applies to injuries that arise from risk inherent to the activity. That's the Brenden case. In this context, the assessment of whether a risk is inherent to an activity depends on whether a reasonable person, under the circumstances, would have foreseen the particular risk that led to the injuries. Bradley's injuries did not result from being hit by a tennis ball by an opposing player. It didn't result from a game of tennis. His injuries didn't result from an errant ball from an adjoining court, nor did it result from a ball hit by a player while Bradley was picking up tennis balls as instructed by his coach. Our position is simply his injuries did not result from a risk inherent in tennis and therefore not reasonably foreseeable. In the Brenden case, the court clarified that certain factors should be taken into account to determine whether a risk was foreseeable. The proper analysis centers on whether a reasonable person in the position of the injured participant should have foreseen the risk. The test is an objective one and focuses on what risk a reasonable participant under the circumstances would have foreseen. The participant must have been able to foresee that the injury could arise through the mechanism it resulted from, and it is also relevant whether the participants engaged in any regular departures. I believe our case judges more akin to a football player after a game in frustration, removing a helmet and throwing it back over his head, hitting a player sitting on the bench. Such an act is not inherent in the game and therefore not foreseeable.
Mr. Jakeway, let me interrupt you and see what questions my colleagues have, and if you have more time, you can keep going after that. But I don't want to use up all your time before we see who wants to ask you questions. I'm going to start with Justice Zahra.
Thank you, Mr. Jakeway. Brenden gives us some things to consider, some factors to consider. But as I go through them, they weigh against each other. And I guess the first question I have for you is, do you view Burton as a exclusive list, or are there other things we can take into consideration in making this initial determination?
Well, Mr. Justice, it certainly is an important case, and there's no question about that. There are other factors that may be taken into consideration. I believe the case is straightforward, however, and our case fits well within the reasoning of a jury question on foreseeability.
Are there any other factors you'd like us to consider in your case, apart from Burton, or do you think Burton does all the work necessary for you?
There is a factor about the position of the appellee stating that Coach Bellard telling the students not to hit a ball against a fence or not to engage in horseplay is just that. That is not set forth in the evidence, and they may argue that those warnings mean that this conduct may have occurred before, but that cannot be effectively argued, Judge, because there's no testimony that those things occurred. Previously, the coach was doing what a coach does, and that is to initiate rules for safety. It doesn't permit a jump. That such activity must have occurred previously and therefore was an inherent part of the game or practice that was expected. I hope I've answered your question by that.
Okay, thank you very much.
Thank you, Judge.
Justice Viviano?
No questions, thank you.
Justice Bernstein?
Counsel, good morning. Is there a code of conduct that needs to be followed as it pertains to the participation in the sport?
Yeah, I think so, Mr. Justice. I believe the conduct is set forth in the rules of the high school association, and also just the conduct that people adhere to in a game of this type. You just would not hit a ball behind you without looking after a game has ended.
Thank you. No other questions.
Justice Clement?
No questions.
Justice Cavanagh?
No questions for me right now.
Justice Welch?
No questions.
Counsel, I have a question. It feels to me like this is one of those cases where you could define the risk narrowly or broadly. I mean, obviously getting hit with a tennis ball is one of the risks inherent in tennis. And I understand your view to be, but the particular way your client was hit with the tennis ball was not a risk inherent in tennis. But do you think that our precedent gives us any guidance about how narrowly or broadly to define the particular risk in a case?
I'm not sure that it does, Judge. I think that each case should be viewed on its own merits.
Okay. You have some additional time if you would like to use it. You can also reserve time for rebuttal whenever you feel that's appropriate.
I would only like to say the act of the defendant aptly removing a ball from his pocket and hitting it without looking, we believe is not foreseeable. It's not inherent or part of the game of tennis, and therefore a question of fact should have been noted by the trial court. I'm delighted that the court would permit this hearing on our application to leave. Thank you so much.
Thank you very much, Mr. Jakeway. Ms. Nemeth, you may proceed.
Good morning, Mary Nemeth on behalf of the defendant appellee, Brenden Remillard. The question this court is focusing on was the risk of plaintiff being hit by a tennis ball reasonably foreseeable under the facts of this case? So here's the scenario we have. You have plaintiffs standing behind a group of 4 teenage boys that are finishing up a doubles match. Both lower courts looked at this scenario, and you have a photograph of the general area in the defendant's appendix. They looked at this scenario. Both courts applied the Burton factors and said this injury was reasonably foreseeable. And I want to focus on 3 facts. Number one, and I think is really important, is where was plaintiff standing at the time he was injured? He's standing only 10 feet behind defendant and his doubles partner. You have 2 other teenage boys on the other side of the court. They're hitting balls in plaintiff's general direction. And to say that, as I would put it, plaintiff is standing in a zone of danger. It's foreseeable that a ball is going to go beyond the baseline and in the direction of the plaintiff. Another factor the lower courts looked at were the characteristics of the participants in their relationship. We were talking about teenage boys. They're their teammates. When teenage boys and adults are playing competitive games and lose a point or lose a match, they get frustrated and they do stupid things. Plaintiff wants to focus on the differences in his age and experience. Defendant is a senior, he's been on the team longer. Well, Richie Gamester answers that question because it talked about different ages and experience levels when people participated in an open skate. So that's not the determining factor. The third point, and this is the one that the lower courts really emphasized, were the coach's admonitions to his players, saying you don't hit tennis balls towards the fence, you don't hit balls after your match is over. And defendant violated that rule. And that is what the plaintiff is focusing on. And I think Mr. Jakeway and I are resurrecting the debate that, between the concurring and majority opinions in Richie Gamester. The concurring justices would have applied a negligence standard to injuries that occur from rule violations. And I think Burton rejects that proposition, the idea that the standard of care, the duty, turns on rule violations, because the Burton court wants courts to look at not only the rules, but any regular departures from the rules. And as both lower courts said in this case, you know, if it never occurred on these team practices that players would get frustrated and hit the balls toward a fence or, you know, do something similar to what the defendant did, why would he even have to admonish his players not to conduct themselves that way?
Ms. Nemeth, let me interrupt you as well and just see what questions folks have. Okay, thank you very much. Justice Zahra.
Thank you. I'd like to explore your understanding of Burton. As I read Burton, it gives us some factors to consider and factors that should be weighed against each other. I don't view any one factor as dispositive, but just factors to be considered and weighed against each other. As I try to go through those factors, I see things that could go either way, but I don't view it as an exhaustive list. So if we were to write an opinion to supplement something to Burton, some factors to be considered, is there anything you would put into that opinion?
To be honest, off the top of my head, I think Burton laid out in a very general way, and that's what you have to do when you create rules for lower courts, the key factors. I'm trying to think, in this particular case, what further should be considered. If perhaps what the Burton factors don't talk about is what I said, the zone of danger. Where are you physically located in relationship to a projectile, another player, things like that. But other than that, I think Burton's thorough.
How are we to determine the depth or the breadth of the inquiry into whether this is foreseeable?
Well, you look at the nature of the game. When you're talking about balls bounce. Tennis balls probably bounce further than footballs. If you're looking at soccer balls, I think it depends on, you focus on what is the nature of the sport, what's the nature of contact, non-contact, things like that. So you start with what is the recreational activity.
Okay, thank you very much.
Justice Viviano.
No questions, thank you.
Justice Bernstein.
Good morning, counsel. I just want to do an analogy. Would you see this to be analogous to a golfer throwing a club or a baseball player being angry and frustrated and throwing a bat?
It's similar. It's similar. Again, how often, it definitely occurs. I think this case presents a more likely, the most common scenario is a tennis ball, excuse me. We aren't involved in this case with the defendant throwing the tennis racket towards the fence. Now that might be, if that regularly occurred, okay, but we're dealing with something that is really a common mechanism of injury, the ball as opposed to the racket.
Thank you, counsel.
Thank you.
Justice Clement,
No questions.
Justice Cavanagh.
Yeah, I have a few. Good morning, Ms. Nemeth. Always good to see you. I have a couple questions. One, I think your reference, you say balls bounce. This ball, in fact, didn't bounce though, right? I mean, would you agree that there's a different risk of injury from a ball that is hit straight from 10 feet away directly into the eye and a ball that comes from across the court and bounces errantly and strikes somebody?
I think we're starting to make the quote, fine Philadelphia lawyer distinctions. Did the ball bounce before it hit? Did it go directly into plaintiff's eye or arm or something like that? I think those kind of distinctions, when you think about the myriad types of scenarios for baseball, basketball, soccer, I think you're going to be running into trouble with lower courts trying to apply those distinctions.
Doesn't Burton direct us to look at the particular mechanism of injury here, and just sort of errant balls leaving the playing, the course or the tennis, field is not, I mean, I think that doesn't, under Burton, that strike you as too general? I mean, we're looking at the mechanism of injury here, which is somebody intentionally hitting a ball 10 feet behind him out of frustration, as opposed to just, balls bounce in and off of tennis courts from all different angles. Doesn't Burton suggest we have to be at least that specific as to the particular mechanism of injury?
Well, if you look at some of the footnotes in Burton, and they cite out of state cases, I think New York, you don't have to foresee the exact mechanism of injury. You don't have to foresee that you're going to be hit by a ball by your teammate out of frustration backwards. You have to look at the general mechanism. I'm not saying just for the concept that balls bounce. You have to, again, look at the location, where does this occur, the circumstances. So you don't have to do it precisely, foresee it precisely.
Okay, and then my other question, and I think both Mr. Jakeway and you focused on that, the concept of regular departures, and both the trial court, as you have said, testified that the coach testified he regularly reminded the team members not to hit balls into the fence, and the Court of Appeals picked that up as well. I'm wondering if you can help show me or tell me where in the record that is, because I have read the deposition of the coach as well as the plaintiff and the defendant, and I do not see that reference. Can you help me or point me to where in the record that perhaps specifically in the coach's testimony, but if it's otherwise, I'm open to hearing that too, as to where it's in the record that this was regularly, that they were routinely hitting balls, or the coach had to remind them routinely not to hit balls into the fence.
The testimony regarding the coach's admonitions appears in the plaintiff's deposition. So if you look at my statement of facts, I'm referencing the plaintiff's deposition. So okay, that's where you get it.
Now, coach who testified, you're saying it's actually the plaintiff who testified.
The clearest testimony comes from plaintiff's deposition.
That this was routinely done, and the coach routinely admonished them not to hit balls into the fence.
There is testimony from the plaintiff saying, I never saw my teammates engage in that behavior. There isn't any specific testimony, I'll be honest, from the coach or otherwise that says, oh yeah, these players routinely did this. But what the lower courts focused on was, if this had never occurred, why is the coach telling his players, don't do this?
So, and I don't mean to belabor this, but the trial court said that the coach Ballard testified that he regularly reminded the team members not to hit balls into the fence.
If you'll give me a minute, let me see if I can look at my brief and check.
67A of the appendix, which would be, from what I can tell, the closest that the coach gets to testifying about this practice, or whether it was a rule or what he had to, what he said to players about it, is page 12 to 13 of his deposition, where they're generally on that topic. I just don't see that even the suggestion that he had to regularly remind team members, and it appears then the Court of Appeals just sort of picked up that. And I just want to make sure that that is in fact the record, if that is going to be the basis for saying that this is an accepted regular departure from the practice.
Without looking further into the testimony in the brief, I would say that the word regularly, repeatedly, or whatever the lower courts use to describe how often the coach admonished his players, that does not appear on the record that I can specifically recall. Okay. But it was a well-known rule by the players. Plaintiff actually knew it, and so did the defendant.
Okay, I appreciate that. That's all I have. Thank you.
Thank you.
Justice Welch?
Yeah, thank you so much. Just Ms. Nemeth, just one quick question. Does it matter at all to our analysis? Obviously, we're having lots of discussion about the mechanism of injury and what is that mechanism. Is there a difference between, Justice Cavanagh got into this a little bit, but is there a difference between a ball hit across the court that maybe bounces or is sort of the normal course of play versus something that's hit on the same side of the court, doesn't bounce, obviously far higher speed, hitting someone? Is there a different analysis?
I don't think there should be. I mean, that kind of, the difference in those facts perhaps goes to how severe the injury is going to be. If your ball is struck 10 feet away versus 20 feet away, it's going to result in a more serious injury. But as far as the mechanism is a ball being directed, going in the general direction of the plaintiff. And whether it bounces or not, or whether it's a straight shot, or whether it's the ball is hit close to the plaintiff or further away, I don't think that should make a distinction as to the mechanism of injury inquiry.
Thank you.
Counsel, I have one question. That the treatises like Dobbs say that conduct that substantially increases the risks that are inherent in the activity is conduct for which someone may be liable, even just at a negligence level. So I'm trying to think about how you would describe this particular conduct. Is it squarely inherent? Is it a squarely inherent risk in tennis that especially maybe high school boys can get frustrated and hit balls at a hard in the way that happened here, or would you more fairly say that this was conduct that might have increased the risks that are inherent in high school tennis? What's your view on that?
I'm trying. Your question kind of implicates the idea of negligent conduct versus reckless misconduct, but I don't think that's where you're going.
No, I'm just curious. And the Dobbs treatise, for example, says that you can't avoid liability for negligent conduct that increases risks that are already inherent in the activity. I'm just wondering how you think about whether this was conduct that is just squarely inherent it's a risk that just comes with the territory, or is it a little bit different? Is it sort of adjacent to the risks that come with the territory? Do you know what I mean? I'm just trying to map this onto the sort of the way the treatises think about this question.
Well, the risk, I keep going back, the risk is being hit by a tennis ball when you're in a location where this is a possibility. It's reasonably foreseeable that this ball is going to travel in this direction. You're not across, beyond the fenced in area. The distance that a ball has to travel that makes a difference in whether you apply a negligence or reckless misconduct standard, I'm having difficulty saying that that fine distinction is going to make all the difference in the world, that you have to measure how far or how hard a ball is hit or thrown.
Thank you, counsel. We used up all your time. Mr. Jakeway, you have some rebuttal time. Are there things you'd like to say to us?
No, Your Honor, I will waive my rebuttal and thank the court.
Thank you very much. The case will be submitted. Thank you both for your presentations.